Okay, our next speaker for this afternoon is Larry Anderson. He is the Distinguished Professor of Law from Drake University, and he is going to be talking about, we're going to actually look under the hood, the pros and cons of using law to achieve environmental quality. Welcome.
Very much. Actually, it's Jerry Anderson instead of Larry, but I don't really care what you call me. That's right. It's the bifocals. So look, I'm a lawyer and a law professor, so I come at this from a slightly different perspective that I know a lot of you do, and so I know, I've seen the projects out there, and you all know much more than I know about the mechanisms to clean up water. You're out there on the ground doing projects that are actually improving water quality in Iowa. And I come at this from a slightly different perspective. I've taught environmental law now for over 20 years. I have a book on environmental law practice. I'm also a litigator, so I've been involved in litigating water quality cases in Iowa for 20 years. You might be familiar with TMDLs, water quality improvement plans, as DNR now call them. I was part of a team of lawyers that brought the case that basically forced DNR to start doing those TMDLs, or water quality improvement plans, back in 1998. And so the whole water quality TMDL program in Iowa is basically my fault. If you like it, then I'll take the credit, but if not, it's really my fault. So, but we also did the agri-processors post-spill case, which involved water pollution that was going into the Yellow River, killing trout in the Yellow River, and I was part of the team that brought that case that really, I think, changed some aspects of how DNR does variances for water quality permitting in Iowa, and we think made a positive change. So my perspective is, you all know that there are ways in which we can improve water quality in Iowa. And the question is, how do we accomplish that? How do we get people to use those mechanisms? And we basically have three ways, right? I mean, we can either teach people, educate people, try to show them, and hope they do the right thing. And part of that can be if it turns out to be in their best interest. If it saves them money, then they naturally will do it if we just educate them. So that's a part of the puzzle. We can also incentivize them, so we can give them the carrot. We can use grant funding, and we can use cost sharing and try to facilitate the wetlands, the buffer strips, the whatever it is that we need to improve water quality. And that's a piece of the puzzle. But I'm really here to talk about the last piece of the puzzle, which is the stick. To what extent does it make sense to use the law to mandate change? And so what are the advantages and disadvantages of using the law to try to force people to change what they're doing and to achieve water quality improvement? And so we have a mechanism to do that called the Clean Water Act that's been around since 1972. And so one of the things that we want to look at, and the reason I call this talk Looking Under the Hood, is because we have a mechanism, the Clean Water Act, that is supposed to achieve water quality. When Congress passed that, they stated explicitly as their goal that the purpose of it was to achieve water quality, fishable, swimmable waters within a relatively short period of time. Well, it's now been over 40 years, and the state of water quality is something I probably don't need to really tell this audience, but we have the 303D list of impaired water bodies. This is the map of the 2014 draft list, and it changed a little bit in the final list, but this gives you a pretty good picture, which is something that you probably all are familiar with. We have a total of 572 impaired water bodies on the 2014 list, 751 total impairments. A lot of Iowa is covered on this list. This is, when we brought the TMDL suit back in 1998, the 1998 list, I think, had 190 some impaired water bodies. And so this is now about triple the amount from 1998. Part of that, of course, is that we have improved monitoring, and we have maybe slightly some additional water quality standards that are being violated. But we have certainly a pretty bleak picture if you look at it from that perspective. Sometimes people ask, well, what percentage of waters are really impaired? You recognize, I'm sure, that not all water bodies are assessed. And of the assessed water bodies, this 304B or 305B study shows that only about 20% of streams and rivers are good water quality. About 80% are either impaired or potentially impaired. Lakes and rivers do a little better. About a third of them are good. The 2/3 not good. So we have, the point I'm trying to make is that we've had over 40 years of the Clean Water Act, and I am not going to stand up here and say that it hasn't helped. It has helped. We used to have basically uncontrolled discharge from city sewers into our rivers and lakes. We don't have that anymore. We used to have factory discharges that were very toxic and horrendous. We don't have that anymore. But we also recognize that it hasn't done everything that we want it to do. And so the question from a lawyer's perspective is, why is that? We look under the hood and we look at this mechanism that Congress enacted to try to deal with this problem, and we say it's not working, at least as well as we want it to. And I sort of analogize this to the fact that the mechanism that we use today is like driving a Model T down the Autobahn. In other words, in 1972, Congress was dealing with a much different problem than we have today. The main problems that they were dealing with were things like the Cuyahoga River catching on fire. So they were dealing with point source industrial pollution, untreated sewage from municipal sewage plants, and so they enacted a law that basically focused on those industrial sort of point sources that they found to be most problematic. And so what we know in Iowa, however, and I'll go back to this slide, I think it's kind of out of order, but what we know in Iowa is that 90% of our problem comes from what is called non-point source pollution. In other words, a lot of it from the fact that we have 92,000 farms in Iowa. We all know that we're number one in hogs, number one in corn, number one in eggs and soybeans. So we know that when we have a land base that is 86% used for agriculture, that a lot of the problem is going to come from those sort of diffuse sources. And so we know that a lot of our problem in Iowa comes from sediment, soil erosion, nutrient runoff, pesticides, and so on. So why doesn't the Clean Water Act deal with that? Well, if we go back to this slide, it's because the Clean Water Act, number one, only deals primarily with point source pollution. So anything that comes out of a pipe is fairly heavily regulated. You have to get a permit. The permit is going to make you use the best technology available. If that's not enough to meet water quality standards, then you might even have to do better than that. And so we place a lot of emphasis on point source discharge. What about non-point source discharge? The Federal Clean Water Act does basically nothing. It leaves it up to the state to control it. And if the state doesn't do anything, then you're left with basically a voluntary approach with no mandated requirements. So the result is that when we say that we're looking under the hood and we're trying to figure out why this doesn't work very well, part of the problem is that the Clean Water Act was not written to deal with agricultural pollution, and in fact doesn't address it in any meaningful way. So I wanted to talk about some of the litigation that's occurring now, because some of it you may have heard about. I know you've heard about the Des Moines Water Works case, unless you've been living under a rock. And try to explain why those cases are being brought. And so what I say is that those cases are basically trying to fit a square peg in a round hole. In other words, we have a situation where the law as written doesn't deal with non-point source pollution very well. We have, as you know, the governor's, the nutrient reduction strategy that basically takes a voluntary approach, a supportive approach, an education approach, an outreach approach, but doesn't itself mandate anything in terms of requirements for agricultural operators. And so looking at that, the Des Moines Water Works is dealing with getting most of their water from the Raccoon River that is impaired for nitrates. And the drinking water standard for nitrates is 10 milligrams per liter. Often, the Raccoon River does not meet that standard, and so in order to provide safe drinking water for the communities that it serves, the Des Moines Water Works has to treat it. So they've installed a relatively expensive nitrate removal system, which is nearing the end of its useful life, so it's going to have to be replaced at a cost of at least $76 million. It costs a certain amount to operate and maintain, which they're having to spend. And so from the waterworks perspective, they're having to spend a lot of money to deal with the problem that is being caused upstream. And so the water quality improvement plan for the Raccoon River shows that about 90% of the Raccoon River's nitrate problem is coming from non-point sources. And a lot of that is from agricultural land upstream. We have the nutrient reduction plan that shows that there are ways in which we can reduce nitrate pollution, and so we know that it could be solved, but we also know that it will cost a lot of money, and so I'm going to talk about that a little bit later too. But the Des Moines Water Works is looking at the nitrate policy and seeing that it's probably not going to make an appreciable difference anytime soon. That it would take a lot of money, as the plan points out, and in fact from $77 to $1.2 billion annually in order to achieve the kind of reductions that will be necessary, and we don't have anywhere near that kind of money being appropriated. So, despairing that anything might happen, the waterworks tried to figure out how they can use the Clean Water Act to achieve this result. They also have some other claims in their lawsuit: nuisance claims, state law, common law, what we call common law claims of nuisance, trespass, and that kind of thing. But I'm going to focus on the Clean Water Act today. So they looked at this map, which comes from, again, the Water Quality Improvement Plan, the TMDL for the Raccoon River. This is the Raccoon River watershed. And the dark red parts are where the most of the nutrient loading is coming from. And you can see that if you look at this map of the three counties that are being sued, here's Des Moines down here, the three counties being sued are where a lot of that nutrient concentration is coming from. So that explains in part why they chose those particular counties. The suit alleges that tile line discharge from the drainage districts in those counties is one of the primary causes of the nitrate pollution in the Raccoon River. And it attempts to control those drainage tile discharges as point source pollution and therefore controlled by the Clean Water Act. So if you remember just a little while ago, I said that Clean Water Act has this dividing line that's pretty dramatic. Point source, if you're a point source, you have to get a permit, you have to use best technology, you might even have to do better than that in order to meet water quality standards. If you're in the non-point source world, the federal law doesn't apply, and you really don't have to do anything in terms of mandated water quality requirements. And so the effort is to move as much as we can into the point source world so that we can get control over it. Because if you can't move it into the point source world, you can't control it under the way the law is currently written. So the idea is to say that when you have an area, I think I've got this is, you all know what tile drainage is, but in this area, this is the same watershed, and you can see that these purple areas are where tile drainage is likely. And so a lot of the area, and in the North Raccoon, it's over 75% of the land base is drained by tile. So a lot of tile drainage in this area of Iowa. And so the allegation is that if you're going to control point sources, what's a point source? Well, a point source is any discernible point where water pollution is being discharged into the waters of the United States. And so this is a pipe. Why should we treat that pipe any differently from the pipe that comes out of the sewage plant or the pipe that comes out of the factory? And so therefore, this needs a permit. And if it does need a permit, then we can try to mandate technology requirements or reductions based on best practices and that kind of thing. So the lawsuit has a significant hurdle to overcome, and that is that the Clean Water Act, due to the I don't know. I was going to joke about it, but maybe I shouldn't. If I'm on tape, I don't want to say anything. I was going to say, due to the lobbying efforts of our senators and representatives back then, it has an exclusion for stormwater discharge from agriculture. Agricultural stormwater discharge is exempt. So whatever else you might think a point source is, it can't be stormwater agricultural discharge. Totally exempt. And so for years, agriculture has basically felt pretty solid in not worrying about the Clean Water Act in this sort of scenario because they think that this is stormwater discharge. The Des Moines Water Works, though, says, well, it's not really stormwater. What these tile lines do is actually, these are tile line discharge points that many of you have, I'm sure, seen examples of. These are the Des Moines Water Works did sampling, and all these red ones are over the limit. So you can see they did a lot of sampling before they brought their suit. But the point is that this is not agricultural stormwater. It's actually lowering the water table. So here's the idea. And again, many of you know the science or the technology behind this better than I do, but the idea is that this tile line actually lowers the water table so that these roots can go deeper. And so it's not really storm water, it's percolating groundwater that's being discharged. And if that's the case, then it doesn't fall under the stormwater exemption. That is the litigating issue that will really decide the case, I think. The case is currently set for trial in August. They certified some questions to the Iowa Supreme Court recently that the Iowa Supreme Court is going to have to deal with before that trial can go forward. So it may or may not occur in August, but if it does, when it finally does occur, the question will be based a lot on the scientific evidence of whether or not this is really stormwater or is it groundwater. We know it's polluted. I mean, there's no question that it's polluted with nitrates. So what I want to say is, I'm not up here advocating for the Des Moines Water Works or against them on either side of this case. I don't have a dog in the fight. But my point from an academic perspective is this. Clean Water Act was not written to take care of this problem. We're dealing with a law that was written in 1972 when the main problems were not agricultural. We didn't have the concentration of agriculture that we had today. We had the main problems being industrial, the main problem being municipal sewage plants. The law needs to be rewritten, right? And one of the things I think is, the title of this talk is sort of talking about the drawbacks, the advantages of law and the disadvantages of law. Well, one of the disadvantages, I think, having looked at this now for a long time here in Iowa, is that we passed these federal environmental acts in the 1970s to deal with the problem because the states weren't doing anything. The states were afraid that if they passed a law, then all the industry would go to Illinois, and if Illinois passed a law, all the industry would go to Kentucky or whatever, right? And so it was to prevent the race to the bottom. And so we needed a federal approach so that we could eliminate that kind of incentive for each state to sort of pass the lowest amount of environmental controls that it had. But the drawback to that is that we now, I think, have a mindset that this is EPA's problem. This is the federal government's problem. And what we want to do from a state perspective is fight the EPA and do as little as we possibly can to meet the EPA's requirements and no more. And that's the mindset we have, instead of thinking about, hey, this is our watershed. These are our waters, right? And what is it, regardless of whether the federal Clean Water Act covers these things or not, why shouldn't we be proactive in figuring out what to do about it and passing laws that will do it? And we know what they might be. Minnesota, for example, has buffer strip requirements. Minnesota has setback requirements. You can't use fertilizer or manure within a certain number of feet from waterways and so on. So we wouldn't have to. So what I'm saying is that this fight is going to play out in a courtroom up in Sioux City, and we're going to fight about whether this is stormwater or groundwater. But is that really the issue that we should be fighting about? Shouldn't we just be proactively saying, well, this is kind of all ridiculous. We're trying to fit this square peg of federal environmental law from 1972 into the round hole of today's problems. Why don't we deal with today's problems and figure out the best way to do it? So that's my soapbox, which I will continue to get on here in the next few minutes. All right, so these are we know what these you know what these solutions are better than I do. But the question is, how do we get them done? And part of getting them done might be to have enforceable best management practices instead of just voluntary ones. Or if you want to make them voluntary, then provide enough money to incentivize them.
Yes.
All right, so that's number one lawsuit that we're going to talk about. Another example of the square peg in the round hole is the Gulf hypoxia problem. You know about the Gulf hypoxia problem, probably the dead zone in the Gulf of Mexico where dissolved oxygen levels are so low that no aquatic life can survive. The extent of the dead zone and its location varies from year to year, but this is one recent year that shows you how extensive this dead zone is. And we know where the dead zone problem is primarily coming from, and it's kind of us, right? These are nitrate yields in the Mississippi River, and we know from the upper Midwest states is where the nitrates are coming from. So once again, the question that you might ask is, well, we have a Clean Water Act. Why isn't it working? Well, it's not working for a couple of reasons. One is that we're the ones that set our own water quality standards in the state of Iowa. And we don't have any incentive to do anything about the Gulf hypoxia problem. It's not our problem, right? And the federal law doesn't deal with that interstate issue very well. And again, what goes back to the non-point source problem is even if we did do something about it, the federal law doesn't have anything to do with non-point sources really, so we would be sort of helpless to do anything. This is a study, I'm not making these numbers up, this is from the nutrient reduction plan that the task force came up with, and they found out that in order to, the dominant share, 93% of the nitrogen problem that's contributing to the Gulf of Mexico problem comes from non-point sources. 5% 79% of the phosphorus comes from non-plant source. A little bit more of the phosphorus comes from municipal sewage plants. But in any case, litigation is being brought. You might have heard about the Gulf Restoration Network case. The idea is that the first step in solving this problem is to have numeric water quality standards for nitrates and nitrogen and phosphorus. Iowa does not have numeric water quality standards for nitrogen and phosphorus, even though, as you know, nutrients are one of the most common pollutants in the state of Iowa. We have narrative standards. So you say, well, what's the difference? The narrative standard says, well, you can tell if the lake is green and it's got too much algae on it and it's eutrophic, then that's a problem. And therefore, we should do something about it. That's a narrative standard. In other words, free from conditions that will interfere with aquatic life. That would be a narrative standard. But a numeric standard would then try to translate that into, let's figure out what level of nitrogen and phosphorus is healthy for this lake, and then make sure we meet it. We can test the water, and we can look at the numbers, and we can say, is this above that number or below it? And if it's above it, then we need to do something about it. And we can list that lake on the impaired waters list, and we can then go, the mechanism gets started. But we don't even have that first step. We don't even have numeric standards. So Iowa DNR was in the midst of trying to do numeric standards, but that's been shelved as far as I know, right, Susan? We haven't moved forward with that. The Gulf Restoration Network case attempts to force Iowa to do it. They want EPA to say to Iowa, look, your water quality standards are not sufficient. The Clean Water Act gives you the primary authority to do water quality standards, but you have to make them minimally acceptable. You can't just pass crap. So you need to do these, or else we're going to do them for you. So the Gulf Restoration Network case is brought down in Louisiana, and the attempt is to try to force the Mississippi River states to adopt numeric water quality standards for nitrogen and phosphorus, or failing that, to have EPA do it. That case is working its way up and down the courts as well. But now I go back to my soapbox point. Why should we wait for the EPA to force us to do that? Why shouldn't Iowa say, we know that these are two of the most common pollutants in the state of Iowa and are causing the most problems in the state of Iowa? Why don't we, as Iowans, say, why don't we pass water quality standards that are numeric and enforceable, rather than waiting for the federal government to tell us what to do? Soapbox 2. Third one is the Waters of the United States rule, right? Again, probably something you've heard about. A lot of agitation, a lot of fighting about it. Oh, I had these were going to be a lot more cool when they displayed, but hopefully you can see what I mean here. The Federal Clean Water Act only applies to waters of the United States, federal waters, basically. Waters that the federal government has jurisdiction over. So what are those waters? Well, Congress doesn't define them. That is exactly what it says. They're the waters of the United States. You know what those are. So any pollution into the waters of the United States is covered. Pollution into something that's not a waters of the United States is not covered. So this is a crucial, again, one of these crucial dividing lines between what the Clean Water Act can do and what it can't do, is where you divide that. And we would all say, okay, well, the Mississippi River, that's of course a federal water, right? I mean, that's something we definitely think of as a water of the United States. The Yellow River, which I wish you could see here, flows into the Mississippi, and most of us would think, well, that's a water of the United States too. I mean, we want to make sure that tributaries of the Mississippi River are covered. But what about Hecker Creek, which flows into the Yellow River, which flows into the Mississippi River? Is that a water of the United States? Well, now we might start to get some disagreement about this. It doesn't seem like it's really a federal water or big enough to be a federal water. And then what about a wetland that is adjacent to Pega Creek that flows into the Yellow River, that flows into the Mississippi River? Is that a water of the United States? So the question is, where do we draw the line? And we have not had a good answer to that since 1972 about where that line should be drawn. We have a number of Supreme Court cases where the Supreme Court has very helpfully weighed in on this question in ways that are maddeningly confusing and virtually worthless, but we don't. So we don't really know. So the EPA, in the last case, Rapanos, several members of the Supreme Court said to EPA, look, you need to do a rule on this. You need to do a rule that defines this better so people will know what's covered and what's not covered. And so the EPA said, okay, we'll do a rule. So they did a rule, and now it's in litigation in virtually every state in the country, and caused enormous controversy. So again, I'm not going to stand up here and defend the rule or oppose the rule or express any opinion on the rule today. That's not my purpose. The purpose is to say, if you Lord, I had too much coffee. I'm just punching this thing like it's a pinball machine. If you dump pollution into this little creek right here, and it's a mile from the Yellow River, how many of us think we should probably control that? Right? I mean, the problem is that the Clean Water, it would be nice if the Clean Water Act said, we should control anything that has an adverse effect on the waters, on the waters of not only the United States, but any water, right? It would be nice if the Clean Water Act said, any activity that affects adversely water quality should be covered. But it doesn't say that, and the federal government, frankly, is not constitutionally able to write it that way. Instead, the federal government is limited only to waters of the United States. And so we are, again, in court fighting, and it's going to take years for this to be resolved, about this regulation and what exactly, whether or not the federal government has authority over this little thing or this little thing. When in fact, what should we be doing? We should be saying, look, if you destroy this wetland, it's bad. It's bad for habitat, it's bad for water quality, it's bad for flood control. And so why should we be fighting about whether or not the words waters of the United States cover this or not, when in fact we all recognize that it's something that should be covered, whether it's by the federal government, it should be covered by the state then. If the federal government can't do it, then let's do it at the state level. And get in there and say that we need to be able to control things that have to do with water quality. Again, here's an example of looking under the hood of the mechanism just not working the way that we want it to work. The engine's not working right, and it needs to be fixed. And this litigation is not going to fix it either way. It may strike down the EPA rule. So the EPA said, look, here's why we're going to try to resolve this. We're going to say that it covers these things, and you can read this yourself, and we can talk more about it if you're interested. But they very carefully clarified, they tried to carefully clarify what would be covered and what would not be covered. And they know that there are some things that people are really agitated and concerned about. I just have a pond on my farm that's an irrigation I use for stock watering or irrigation. Is that going to be covered? Well, no. I mean, it says we're not going to cover that in the rule. I've got a ditch that runs on my farm. Is that going to be covered? No. We are going to say right in the rule it's not going to be covered. So there are lots of things. The rule is very complex. It's got a lot in it. But the point is that it was an attempt by the EPA to try to clarify what was covered and what wasn't, so that you could know ahead of time whether or not you needed to get a permit for doing something. Didn't work out. It looks like it's going to be a big mess, but it's not going to be any less of a mess if the Waters of the United States rule gets struck down. It just means that those things will get resolved in court instead of by the reg. All right. Last case. This is another case that you may or may not have heard of, probably maybe not since it's up in Washington, but it's a case that could have impacts down here. The Cow Palace dairy case. So this huge dairy operations in the Yakima Valley of Washington. In this particular one, this dairy farm, I think everyone pretty much agrees was bad. It had these earthen lagoons where they were storing manure discharge for a long period of time. The lagoons were leaking into the groundwater. They were spreading the manure on nearby fields at such an incredible saturation that it was there was absolutely no legitimate agricultural reason for spreading this manure that way. They were basically just trying to get rid of it, and they would spread it at depths of feet, of manure, and it was leaking into the groundwater. Okay, you think, well, this is bad, right? Well, there's no discharge into the waters of the United States. It's leaking into the groundwater. Groundwater is not covered by the Clean Water Act. So they had to use RCRA, which is a law that has to do with solid waste disposal. RCRA is the law that prevents you from taking your trash and dumping it in the field. It prevents open dumping of solid waste. Well, we know that most farmers do not consider this solid waste. They consider it fertilizer, right? And so we never think about a farmer spreading manure on the field as being covered by RCRA. That's not a waste, it's a fertilizer that they're using, right? So is it a fertilizer or is it a waste? And so in this case, the Cow Palace case, the court found that they were spreading this, they were storing it for such long periods of time, such that it leaked into the groundwater. They were spreading it at such depths and such oversaturation that it was not fertilizer. It was disposal of solid waste, and therefore they were violating the open dumping provisions of RCRA. So again, it would be nice if we just had a law that said, we think that this sort of lagoon is a possible danger to groundwater, and so you need to do it in this way, and you need to follow these regulations in order to make it safe and make sure that it doesn't cause problems. But we don't have a law like that. And so you have to use RCRA, which was never intended to cover this sort of thing, but try to fit the square peg of RCRA into the round hole of this agricultural practice, because it's the only thing we've got at the moment to try to deal with these problems, because the law is a Model T that is driving down the Autobahn. Okay, so you get my analogy now, is that the law is just not working to deal with the problems that we have today. And it needs to be fixed, but these lawsuits that we see and that may be troublesome and may be weird and confusing, I think the impetus for them is because we got nothing else. We have to use the law that's written to try to, fit it into these problems that it was never really intended to fit. And gee, wouldn't it be nice if we could pass a law that actually was intended for the problems that we have today. So I'm not holding my breath about that, but that's exactly what I'm saying. Okay, so we have a little bit of time left. If you have questions about these things, I'd be happy to hear them. Right, don't we have time? Okay, yes. And where does that come from? Like what program or? Okay, but there's no. Okay. Yeah, and so, I mean, again, as I said at the beginning, there are several ways that we can deal with these problems, and one is by education, you know, and by educating farmers that you may not need this much nitrogen to economically, and it's actually going to be worse for you, your bottom line, if you put on too much nitrogen, and this is the level, and of course we all know that, you know, that if we could educate people and if they can use these modern testing techniques to make sure that they're not over-applying, it's going to save them money and it's going to be good for water quality. But, you know, again, from my perspective, that may not be enough. That's one part of the piece of the puzzle, but probably not all of it. Other questions? Yes?
I wonder if you comment on a state level, your complications of watershed boundaries versus municipal or county, state or boundaries, trying to deal legally with those sort of issues of watershed expand.
Right. And that's a problem, as you can see all the way up, because as I said, the Mississippi River area, that's really the relevant geographic area for the Gulf hypoxia problem. But we don't have a legal jurisdiction that encompasses that. And so, and then at the state level, it's the same way. We're not organized by watershed. We're organized by county or by city or whatever. And so you get what in law we call spillover effects, where you have the cause of the problem in one legal jurisdiction, but the impact of the problem in another legal jurisdiction that doesn't have any authority to do anything about it, right? So they're suffering the consequences, and so it really is a problem of scale that we have not figured out. I know that there are watershed district councils now that the state law empowers, the formation of these watershed councils, which was a good step. However, they don't have any authority other than if they can convince the counties and cities within that watershed to cede them some authority, or to the extent that they can convince the cities and counties in that watershed to do what they think should be done. So it can be a good way to coordinate the different jurisdictional boundaries with that watershed advisory group, but it doesn't have any power. And so unless they have really good persuasive ability, or it just doesn't do what I think needs to be done in that way. So that's a constant problem, that this sort of mismatch between jurisdictional boundaries and where the problem really is coming from.
In one of your slides, you showed the open heat line, I believe it was, under the non-point source. We know that federal rules now consider feedlots or concentrated animal feeding operations over 1,000 animal units as point sources. So we issue NPDS permits for them, and so
Yes.
that I wanted to make that point.
Yes. Well, and I mean, some of them are. Some of the CAFOs are covered. Not all of them. I mean, you have to also be discharging in order to be covered. And so you're right. I mean, there has been some improvement, and again, this falls into my general theme of trying to move as many things into the point source world as possible. So some of the larger concentrated feedlots are covered if they meet certain criteria, but not all of them. And again, what my sort of overall point is that we need to not be so concerned about, is this a point source, does it meet the definition of point source or not, as much as covering everything that has an impact on water quality, whether or not it's technically classified as a point source or a non-point source. But you're right, absolutely. Some of those CAFOs are being covered now.
No, I meant that credit goes to the state too, that we cover these things.
Yes.
Also, if they are not even under over 1,000 and if they have any discharge, and we designate them as discharges, then we issue an EPA.
Yes, right. So do we have time for more? Yeah.
Yes, we have time.
Yeah, so like, dividing your soapbox is like point source, not point source, maybe it doesn't matter. Litigation, of course, is not really the best way to go about this, but are there examples of other states taking the lead on this and developing some sort of non-point source water quality program? Like, in previous EPA or even other countries or other forms of government that are an example of this?
Right. Yeah, and of course, I'm as a litigator myself, I would never say that litigation is not a good thing. But it's not. And what I totally agree that my point is that it's certainly not the best way to go about this problem. But yes, I mean, one of the things that Minnesota, I think, is doing some good things in terms of mandating best management practices for agricultural operations, including buffer strips, including setback requirements for manure application, integration requirements for manure. So they are doing some things. And then on the other end, they also have, like we have, the 3/8 cent sales tax. They actually implemented it. And so they have a fund of money now that is substantial amount of money that they can then put towards wetland projects and that kind of thing. And so Vermont is also an example usually that people look at of more, more comprehensive requirements. So there are certainly examples of things that people are doing at the state level that I think would be good for us to look at as models. Well, the Chesapeake Bay area is a whole other thing that I could have put on the slide, which is basically a TMDL that the federal government did, Water Quality Improvement Plan for the federal government, which then trickles down to the state level for them to implement. And so that's another sort of, again, a way that you can try to, get the Clean Water Act to work better is by having a multi-jurisdictional TMDL that then the states have to figure out how to meet, or else the federal government will come in and try to figure out how to meet. So that has had an effect, and I think the Chesapeake is where the Mississippi River will eventually be going. If the states don't do it on their own, that we'll get a multi-jurisdictional TMDL for the Mississippi River to try to solve the Gulf hypoxia problem, which I don't think any of us really would want. I mean, I think it would be much better for us to go ahead and try to figure out how to improve water quality on our own.
One more question. Go ahead.
Yes, sir. I appreciate your fondness for analogies. And I wonder if, in the circumstance, farmers are to the nitrate and phosphorus problem as a drug dealer is to distribution of drugs on the street corner or elsewhere, and that drug dealer is part of a larger network that the federal government, similarly as the farmer is part of a larger network that includes the seed companies, the equipment companies, the banks, the commodity market, and so on. And since we're trying to fit square pegs into round holes, what about prosecuting offenses such as hypoxia zone and so on under a RICO law?
Let me just say, interesting idea. And I do want to say this, look, my family has plenty of farmers in it, myself, and I certainly, hopefully, didn't come across as demonizing agriculture, and I know a lot of you are in agriculture as well, and I have no intention to demonize agriculture because, as I say, that my background is, my family's in agriculture as well. So So I don't mean to do that at all, and I hope I didn't come across that way at all. But we have to recognize that these studies show that this is where a lot of the problem is coming from. And so we need to address it, and we need to address it in ways that work for farmers as well as work for water quality. But we have to hit it head on. We can't keep trying to use the Model T. We need to sit down and figure out what will work for both sides of this problem in a proactive way. Okay? Thanks.